before His Lordship, Honorable Justice O.O. Eyewumi, Tuesday, 18th July.
Registrar, I can't hear you well. Is there any of the parties in court?
All the parties are absent, my lord.
Appearances. Check your audio, Mr. Onoja. Very well. Any other?
Yes, we prefer respect to this honorable court.
Yes.
My name is Tunji Ojuokai, Acting Deputy Director, Ministry of Justice.
Deputy Director, what? Litigation?
Litigation, civil litigation.
Very well. So
for the defendants. Respondents.
Here is the decision of the court.
Thank you, Lord.
The applicant, by motion or notice filed on the 12th of September 2022, brought pursuant to section 33(1), 34(1)(a) and c, 36(1), 44(1)(2)(a), b, c, 48, and 254(c)(1)(a), d, and k of the Constitution of the Federal Republic of Nigeria 99 as amended, and of the 2 rules 1, 2, 3, and 4 of the Fundamental Rights Enforcement Procedure Rules 2009, Articles 2, 3, 4, 5, 7, 8, 9, 10, 11, 15, and 17 of the African Charter on Human and People's Rights Ratification and Enforcement Act, Cap 10 Laws of Federation 1990, and order or the same. (2017) paragraphs 2.2a, 2.23a, b, d, and e, 4.3a, 8.3 to 5.5, and 8.8 of the revised edition of Schemes of Service for State of the Polytechnic Law 1994, and under the inherent jurisdiction of the court, praying the court for the following orders. 1, an order of the court declaring illegal, unlawful, null and void, and unconstitutional all that acts of respondents that undermine the subsisting employment rights of the applicant, with the respondent same having not been or been determined by the laid down requirements of the public service rules on appointment and condition of service of the third and fourth respondents and a purported dismissal of civil or public servants. 2, an order of the Honorable Court declaring illegal, unlawful, null and void, and unconstitutional all that acts of the respondents that undermine the proprietary rights of the applicant to her salary or salaries and any other rights thereto relating to her movable property, to wit, her unpaid or standing monthly salaries and allowances for 65 months as a subsisting lecturer in the employment of the respondent from April 2017 to September 2022 and still counting, which thereto violates and are likely to further violate the proprietary rights, financial rights of the applicant to salaries and allowances and denial to free access, collect and make use of her legally earned wages to be wrongful, illegal, null and void, and devoid of constitutional principles and against the rule of law. 3, an order of the court declaring illegal, arbitrary use of official powers, unconstitutional, null and void the act of the respondent, arbitrary, willful, and careless refusal to pay the applicant her salary duly worked for and legally earned salary without just cause and without fair hearing and fair trial, and thereto violate the fundamental rights of applicants to already earn salaries and allowances since the period of April 2017 to September 2022, and still counting, thereby wrongfully deprive the applicant the economic value and usage of her salaries and allowances, and thereby cause applicant an immeasurable financial loss, economic hardship, torture, trauma, and lack of funds to attend to her immediate financial needs. For an order declaring illegal, void, null, unknown to law, and lack of legal procedure, arbitrary use of official powers by respondent without due regard to the rule of law, and in violation of the applicant's fundamental rights of the applicant by the outright refusal to pay salaries and allowances of the applicant from the period of April 2017, September 2022, a period of 65 months and still counting, contrary to section 34, 33, 36, 43, 44, 1 and 2, 254C of the Constitution as amended scheme of service for staff of polytechnic and respondent, hereafter called scheme of service, and articles 2, 3, 5, 7, 8, 9, 10, 11, 15, and 17 of the African Charter on Human and People's Rights Ratification and Enforcement Act. 5, another of the Honorable Court directing the respondent to pay up the total sum of 6.9 million naira, being the outstanding salaries and allowances of the applicant illegally withheld by the respondent for 65 months between the period of April 2017 to September 2022, still counting, and thereby forthwith for the breach of the applicant's fundamental rights to life, dignity, fair hearing, and trial property as guaranteed by section 34, 33, 36, 43, 44, 1 and 2, and 254C of the Constitution as amended, and articles 2, 3, 4, 5, 7, 8, 9, 10, 11, 15, and 17 of the African Charter on Human and People's Rights Ratification Act and Scheme of Service. 6, an order of the Honorable Court reinstating the applicant to her office and position as entitled staff as provided under regulations or scheme of service governing the condition of service of the staff members of the third and fourth respondents. 7, an order of court directing the respondent, especially the third and fourth respondents, not to illegally henceforth withhold the salary and allowance of the applicant save as provided under the regulations or scheme of service governing the condition of service for staff members of the third and fourth respondent. 8, an order of court declaring the action of the respondent that willfully undermines the fundamental rights of the applicant by withholding the outstanding salaries and allowances of the applicant for 65 months and still counting by the respondent from April to September 2022, the legally earned salaries and emolument, the property of the applicant without due regard to law to be illegal and arbitrary and a violation of fundamental rights of the applicant as guaranteed under sections 34, 36, 43, 44, 1 and 2, and 254C of the Constitution. And the consequential order of this Honorable Court directing the respondent to pay forthwith 65 months salary and allowances of the applicant for the period of April 2017 to September 2022 under reference until date. 9, a declaration that the joint action of the respondent refusal to pay off the total sum of 6.9 million naira, being the outstanding salaries and allowances of the applicant to 65 months and still counting, is in violation of the fundamental rights of the applicant as guaranteed by sections 33, 34, 36, 43, 44, 1 and 2, and 254C of the Constitution and the scheme of service could be state polytechnic law and articles 2, 3, 4, 5, 7, 8, 9, 10, 11, 15, and 17 of the African Charter on Human and People's Ratification and Enforcement Act as the lawful actions aimed against the applicant's fundamental rights to means of livelihood, smooth operation and peaceful management of the applicant's simple lifestyles to health, family needs, and thereby cause the applicant economic paralysis, untold hardship, shock, trauma, and loss of money, as a breach or infringement of the applicant's right to human entrepreneurship by disorienting the numerous financial activities of the applicant. 10, and order directing the respondent jointly and several not to further use of the smooth operation and management of the applicant's free access and use of a salary by any stretch of refusal to pay off forthwith to withhold salaries and allowances of the applicant in a purported or orchestrated dismissed by the activities of the respondent since the illegal stoppage of her salaries and allowances for the periods between the month of April 2017 to September 2022, and any further act that is capable to violate, likely to violate, or will violate the fundamental rights of the applicant to her salary and allowances as guaranteed under sections 33, 34, 36, 43, 44, 1 and 2, and 254C of the Constitution, and articles 2, 3, 4, 5, 7, 8, 9, 10, 11, 15, and 17 of the African Charter. 11, an order awarding the sum of 3 million naira to the applicant being damages suffered from shock, trauma, mental torture, and illegal deprivation of access, salaries and emoluments, and illegal refusal to pay off the applicant's unpaid salaries and allowances from the period of April 2017 September 2022 by the respondent, and usurpation of the free use of the applicant and salaries and allowances to attend to our immediate family needs, health issues, business plans, and financial organization by the respondent, arbitrary and unlawful use of power to breach or cause infringement on the applicant's fundamental rights. To have general and exemplary aggravated damages of 1.5 million naira against the respondent for the arbitrary infraction, threat of further infractions on the fundamental rights of the applicant, be it abuse and or wrongful refusal to pay off the salaries and allowances of the applicant for the period of 65 months between 2017 to 2022, still counting to guaranteed rights under section 33, 34, 36, 44. Please switch off your phone. Police, go and collect that phone. 13, 1 million naira being the cost of prosecuting this suit by the applicant with 10% post-judgment interest rate pending the full payment. And 14 is an omnibus prayer. The grounds upon which this application was brought as follows: that the applicant as citizen of Nigeria is entitled to the protection of the relevant laws of this country in equal terms with anybody, no matter how high or low whatsoever in the society. Too, that the applicant is entitled to life by the use of payment of her salaries and allowances from April 2017 to date, as captured in the offer of appointment and implementation of Comcast 8, step 2 of 1.2 million naira, dated August 3rd, 2016, schedules of the third respondent. 3, that the applicant's right as guaranteed by reasons of sections 33, 34, 36, 43, 44, and 254C of the Constitution as amended, and the relevant provisions of articles of the Charter on Human and People's Rights. 4, that the first, third, and fourth respondent. I will take the grounds as read, please, so that we proceed. The application was followed by written affidavit and written address. The respondent responded by filing their counter affidavit and a notice of preliminary objection. So I'll go straight to the decision of the court. A careful perusal of the process on record revealed that the only issue, the determination of which will resolve the dispute before this court, is whether the applicant can commence this suit in this court, vide the manner adopted, fundamental enforcement procedure rules, hereinafter referred to as FREB rules. Addressing the only sole issue framed, it is a contention of the respondent that this suit is incompetent as to the mode of commencement. This action was commenced under the FREB rules. There is no doubt that originating summons and originating motions are similar in nature, in that they are both decided based on affidavit evidence. See the cases of DEC, Oil and Gas Limited, and SNG Limited citation captured. It is a tried position of the law that one of the objectives of originating summons or motion, as the case may be, is that proceedings initiated thereby are very expeditiously dealt with. See the case of ETIM and PDP and other citation captured. Thus, it is clear that the procedure adopted in the two processes are the same, and any procedure applicable in one will be applicable to the other. Courts have held that originating summons and a preliminary objection on jurisdiction can be taken together provided the court determines the objection first before proceeding to address the merits of the case. See the case of General Mohammed and Garba, General Mohammed A. Garba retired, and Mustafa Sani Mohammed and other citation captured, Yadua and others versus Yadoma and other citation captured, Daplalong and others, and Darian and other citation captured. In restating the principle of law on when a challenge to the jurisdiction of court is raised in an action commenced by originating summons, the Supreme Court per Mohammed GSC in the case of AG Lagos State and others, and AG of the Federation and all the citation captured, held those, and I quote, when a preliminary objection is raised in an action such as the present one commenced by originating summons, it is always better to take the preliminary objection with a substantive that if the objection to the action succeeds, the case on or action is terminated in limine. If the objection fails, however, then the court will proceed to determine the substantive action on its merit, unquote. Although the objection was not contained in the preliminary objection, but in the counter affidavit in opposition to the affidavit in support of the originating motion in this case, and also in the written address in support of the court, the court will still consider the objection first before it considers the merit of the substantive action. The objection raised by the learned respondent counsel no doubt goes to the root of this matter, which borders on competence of this court to adjudicate on this matter. The law is well established that once an issue of jurisdiction is raised by either party in an action, it must be considered first. This is because jurisdiction poses a crucial question of competence. See the case of Uni and Cabri Nigeria PLC citation captured. Jurisdiction is the very basis of which any court tries the case. Being the lifeline of all trials, a trial without jurisdiction will amount to a nullity. See the case of Dadan FRN citation captured, Idigbe and Lucy citation provided, Deros Maritime Limited and MVMSC Apapa citation captured, WAMU and WAMU citation provided. Now to the heart of the issue raised by the respondent on the mode of commencement of this action. The jurisdiction of a court must be invoked before a court can be said to be competent to entertain an action. And to determine this, the court must satisfy itself as to the following: that A, it is properly constituted in terms of number and qualification of its members. B, the subject matter of the action must be within the jurisdiction of the court in the sense that it has to be competent to adjudicate on it. And most importantly, in this case, C, the matter is initiated by due process of law with nothing to rob the court of its jurisdiction. See the Lucas Classicals case of Madkulu and Nkem Delay citation captured. The contention of the defendants relates to whether or not the jurisdiction of the court has been properly invoked by the mode of commencement of this action. As stated severally in this case, claimants instituted this action by way of fundamental rights application under the FREB rules. The court in the case of Iheanacho and MPF citation captured held that for a claim to qualify as falling under the fundamental right enforcement procedure rules, it must be clear that the principal relief sought by the applicant is for the enforcement of a fundamental right and not to redress the grievance that is ancillary to the principal relief, which is not a service so facto a claim of fundamental right. That when an application is brought on the rules, condition precedent to the exercise of court's jurisdiction is that the enforcement of rights should be the main claim and not the accessory claim. And where the alleged breach of a fundamental right is shown on the face of the relief's claim to be ancillary or incidental to the substantive claim, the jurisdiction of a court cannot be properly exercised as it will be incompetent to do in the circumstance. The Apex Court per GSC, while delivering the lead judgment in the case of Nwanze and NRC, the 2022 decision of the Supreme Court, a case that borders on termination of employment and enforcement of fundamental rights action under FREB rules, quoted with approval the dictum of Mohammed GSC in the case of Gafar and Governor of Kwara State citation captured, where the court held inter alia that when an application was brought under 1979 Constitution and under 1 Rule 2 of FREB, a condition precedent to the exercise of the court's jurisdiction is that the enforcement of the fundamental right or securing enforcement thereof should be the main on principal claim and not an accessory claim. Thus, where the main claim is not for the enforcement of fundamental rights or securing the enforcement of fundamental rights, the jurisdiction cannot be properly exercised as it will be incompetent. Whereas the JSC, on his own part, while concurring with the lead judgment held us at pages 294 to 295, I quote, when an application is brought under the Fundamental Right Enforcement Procedure Rules 979, a condition precedent to the exercise of the court's jurisdiction is that the enforcement of fundamental rights or securing of the enforcement thereof should be the main on principal claim and not an accessory one. The Federal Ministry of Internal Affairs and Orders and Shugaba Abdurrahman Daman citation is captured in the instant case. The alleged breach of fundamental right of fair hearing under Section 33 of the Constitution of Federal Republic of Nigeria 79 as relied by the appellant at the trial court flows from the alleged termination of employment with the respondent. At the trial court, the appellant sought the following reliefs against the respondent, having regard to all the circumstances of this case, including the reliefs claims, issues for determination and facts opposed to into the affidavit. The termination of employment with respondent was a fundamental issue in this case. It was therefore a cause of action. It is the contention of the appellant that this case is one for enforcement of his fundamental rights, which were infringed upon by the respondent, and the relief sought by it was an ancillary relief, adding that if the trial court grants reliefs 1, 2, 3, would naturally flow from the first two reliefs, unquote. In the same vein, the Apex Court in the case of Ebuonu and BRTC citation captured held that the procedure for instituting an action based on the infringement of fundamental right under the Constitution of Federal Republic of Nigeria is prescribed by FREP 1979, and an action for wrongful dismissal from employment cannot be brought under the rules since it belongs to a different class of action from action on contravention or threatened contravention of fundamental right. The court held further that since in that case, the appellant's main claim, which is based on wrongful dismissal from employment, is founded on contract for him to enforce the claim, he was bound to take out a writ of summons against the respondent in accordance with the provision of Borno State High Court Civil Procedure Rule 79. Also, the Court of Appeal in the case of Briggs and Harry, citation captured, held that for an applicant to successfully institute an action under FREP rules, the claim must fall within sections 33 to 34 of the Constitution, and the court has to determine this by considering not only the affidavit, but also the relief sought to see if it could be said that the breach of such fundamental human right was the main claim in the action. The court held that the order the appellant therein was seeking was glaringly of reinstating him to his post, which signifies that the fulcrum of his action was wrongful termination by failure of the employer to adhere to basic principle of natural justice. That the alleged breach of appellant's right to fair hearing flowed directly from his substantive allegation of termination of his employment without being invited. The court went further at page 75 at paragraphs E to F, that employment issues are not fundamental rights, so they cannot be claimed under the FR fundamental human rights rules. See also the cases of ATA Poly and Meina, citation captured, Jack and UNAM, citation provided, Nigerian Society Institute, TFMB, and ADEBI, citation provided. There's no doubt that this court is imbued with the jurisdiction to entertain actions on fundamental rights as contained in Chapter 4 of the Constitution as they relate to employment matters. See Section 254C, subsection 1, paragraph D of the Constitution. The issue is nonetheless with the mode applicants sought to invoke the jurisdiction of the court. The applicant's allegation that her rights under sections 33(1), 34(1)A and C, 36(1), 43, 44, 1, 2A, B, and C, and 48 of the Constitution have been breached flow directly from her allegation that her salary was arbitrarily stopped and that she was purportedly dismissed unlawfully without any notice, whether 3 months or 1 month. 1 month. There is no way the issue of the alleged breach will be considered without considering the issue of the stoppage of her salary and purported dismissal by the respondents. In fact, what applicant seeks in this case is that her salary be restored and that she should be reinstated back to her position. There's no gainsaying that the real cause of action is unlawful termination as seen or unlawful dismissal, as seen in paragraphs of her affidavit, where she alleged that the procedure and the scheme of service of the Polytechnic were not followed. The alleged breach of a fundamental right is so inextricably linked to the alleged unlawful stoppage. Fundamental right, as seen from all the processes filed by applicant, is only but a means to achieve the end of reinstatement and restoration of salary, which shows that her main grounds is with her dismissal from employment. In my view, applicant could not have brought this action by way of enforcement of fundamental rights since her main claim in this action was for restoration of her employment and salary. Applicant could not have invoked the jurisdiction of this court under FREP rules since her action is merely to achieve a different purpose and not for the enforcement of her fundamental right per se. The proper mode should have been by general form of complaint as provided in Order 3 of the rules of this court 2017. The applicant action by way of FREP rules is no doubt incompetent. Assuming, but I'm not definitely conceding, that the applicant has sufficiently invoked the jurisdiction of this court by the mode she used in commencing the suit, I've carefully read the affidavit in support of the originating motion, further affidavit and counter affidavit, and I'm of the view that the respondent allegation of non-clearance of the applicant, as well as other irreconcilable conflict, will not make originating motion the proper mode of determination of this action. Order 3, Rule 2B of the rules of this court provides that where any matter relating to Section 254CD of the Constitution is to be filed before the court, such a matter, if it relates to interpretation and application, shall by way of complaint, surely any attempt to prove the liability of the respondent through originating motion procedure where affidavit and counter affidavit and being subsistence of substantial dispute must be resisted by the court. It cannot be otherwise. For substantial dispute will only be resolved in the usual adversarial proceedings upon the settlement and exchange of pleadings. Averment in pleadings borne out by oral evidence tested in cross-examination. See the case of Cameroon Airlines and Ututu citation captured, Udutola and Paper Sack Nigeria Limited citation provided. To my mind, that approach was a sacrilegious affront to a basic requirement that a person who is so confronted should be able to confront his accuser. This is usually done through cross-examination or by the confrontation or contradiction of all the witnesses that testifies against him. See the case of Daudu and MPC citation provided. Again, with the allegation that the applicant was not cleared by the staff screening committee, coupled with other irreconcilable conflicts in the affidavit, counter affidavit, and further affidavit filed by parties, it becomes crystal clear that there is palpable dispute on the fact which make the proceeding hostile, contentious, and unsuitable for adjudication under the originating motion as we have under fundamental human rights application. See the case of Ekanem and others, and the registered trustees of the Church of Christ, the Good Shepherd, and others on reported appeal number SC/349/2011, judgment delivered on 2nd of December 2022. I bear in mind that it is not all disputes that will be material to call oral evidence. However, the dispute between parties in this case are so material that they go to the root of the case at hand, which in my view cannot be resolved by affidavit evidence. The point must be made that facts are the springboard of law, as it is the facts that will determine the appropriate procedure to be adopted in instituting an action. The fact of this case clearly show that the dispute cannot be resolved on affidavit evidence, as there will be need to call oral evidence. This is because facts are most times inconsequential or play infinitesimal roles in suit commenced by either originating motion or originating summons, as they are basically for review of administrative powers or orders and interpretation of documents, unlike the general form of complaint procedure, where facts are the bedrock of the action. Applicant's allegation that he was not invited before any panel or indicted before the stoppage of his salary and his allegation of purported dismissal are all allegations of facts that must be tested under the fire of cross-examination. It is thus improper for her to have commenced this action by way of originating motion, especially in this case where facts are contentious as seen in several affidavits filed by each party. Just recently, the Apex Court in a majority decision in the case of APC versus Bashir Sharif and two others on reported appeal number SC/CB/1689/2022, which was delivered on 6th of February 2022, held that failure of the respondent in the action to commence his action, which was contentious to institute his action by way of writ of summons, was fatal, and his action liable to be set aside because the procedure adopted to ventilate grievances is wrong and the process ought to be struck out. In view of all status supra, this court finds that it cannot successfully determine the action by way of enforcement of fundamental right. Also, the Court of Appeal in the case of Ufuku and Izabi on Die citation captured held those, and I quote, where an originating process initiating a suit is found to be incompetent, the court of law would not have jurisdiction to adjudicate on it, for an invalid process cannot initiate a suit in the court of law. The failure to commence proceedings with a valid writ of summons go to the root of the case, and any other emanating from such proceedings liable to be set aside as incompetent and a nullity, unquote. I'm aware that the respondent in this case initially filed a preliminary objection to the jurisdiction of this court on the ground of being caught by the statute of limitation. However, the said process was withdrawn on the 13th of December 2022 by the respondents and accordingly struck out. The position of the law is clear that when a court process is withdrawn by the party filing same and struck out by the court, cannot be utilized by any party or the court again. See the case of UNC and Ali citation provided. It is in the light of this that the court did not bother itself with the issue of jurisdiction raised in the already struck out notice of plenary objection, which is almost similar and in all fours with the current objection in the counter affidavit. For the above reasons, this matter cannot be adjudicated in this court, having been commenced by FREB rules. It is consequently struck out. And this will give the applicant the opportunity of coming properly before the court. Parties are to bear their respective costs. Judgment is entered. Copies of the judgment will be forwarded to you in Lokoja.
We are most grateful, sir.
Very well. So I will rise for now in Lokoja. I hope my message was passed on to council. I have a meeting, a program to attend to on behalf of the Honorable the President of this court, the Nigerian Bar Association section on legal practice. They are having a meeting. I believe that some of you may be there. And hopefully some of you can join virtually. So I have to be there as one of the panelists. So permit me to be out of this court today. Thank you very much. I will rise.